points, my lord, not to repeat anything. We have, I think, heard, my lord, the same thing over time and again. My lord, if your lordship may just have a note, my lord, we had filed it. And my lord, there are brief submissions which are put in the index itself. The points have been flagged, my lord. First point, my lord, if your lordship have got that note, Hold on a second.
What aspects will you be dealing with, Mr.
My lord, I am dealing with the 3 or 4 aspects, my lord. One being on Nabam, my lord, very briefly, which is not specifically highlighted. Number 2, my lord,
42 pages.
Kyoto para 122 with relation to 21B. And my lord, the 2 judgments which they have relied upon on the other side to contend, my lord, that there is a permissibility under the constitutional scheme for the court to deal with a disqualification petition directly. And the Karnataka judgment is, my lord, a Bible on not attending meeting constituting a disqualification under 21A. Lord, I am going to, with reference to para 122 of Kyoto, it is only 2 kinds of meetings, my lord, which fall under 21B. This, my lord, the first point is, my lord, Nabam. And that, my lord, respectful submission is rule against participation of the speaker till the time, my lord, the removal resolution process is completed. My lord, if your lordship may come to the index, kindly skip the first one. My lord, there is a 1-page index.
Rule against
So,
participation.
first point, your lordship may skip on the relevant dates your lordships have considered, noted down. I am not reading anything from there. The first is rule against participation of the speaker. Kindly come to that at page 5.
Page 5.
And, my lord, your lordship may take it, my lord. I am not reading anything unless, my lord, your lordships have not seen any part. Now, my lord, rule 181 is against participation of the speaker. 179 is removal. Now, my lord, my respectful submission is 181 is founded on the basic principle of conflict of interest. That where you are personally involved or your personal action is or activity is going to be considered, you should remain out. This conflict of interest, my lord, gets elevated to the level of constitutional adjudication. A conflict of interest at the degree, my lord, even in executive functioning, if you have to now test it for a constitutional adjudication, the level would be far higher. So, my lord, there is a dissent, my lord, intra-party dissent which can be shown. And, my lord, the rule against participation of the speaker. And, my lord, this became a question in the constitutional validity challenge which was laid before this honorable court in Kyoto. That intra-party dissent is also a part of the constitutional scheme as well as democracy. How do you create a balance? This, my lord, is laid down, and I made a submission earlier, my lord. The proviso to 179C is the beginning of that rule against participation. Proviso to Article 179C is the commencement of the time duration. I'm sorry.
No.
Yes.
Time duration of commencement of rule of non-participation, and it gets concluded in terms of the main provision of 179C when the removal resolution is considered in the House. Kindly have a look at that, my lord. 181(2) is rule against participation. This is my submission, my lord, based on the conflict of interest and when it is to be tested in the touchstone of the constitutional adjudication, because clause 6 of the 10th schedule is constitutional adjudication by the speaker. Now, my lord, if your lordship may kindly see the next page at my lord, page 6 of my written note, para number 5, which reproduces the relevant portion of 179C.
Yes.
And I'm not going to read it, my lord. My respectful submission is that the proviso is the commencement of that non-participation period to begin, and main proviso to 179C is the conclusion when the removal resolution is taken in the House. Then, my lord, clause 11 from the legislature rule, Maharashtra legislature rules have been reproduced. I am not reading it. I want to read, my lord, these three paragraphs again from Justice Deepak, Honorable Mr. Justice, as his lordship then was not Deepak Mishra's judgment from para 235 to 238, which are reproduced at page 8 and 9. Now, my lord, when this conflict of interest is raised to the level of constitutional adjudication, and, my lord, the inter-party dissent is to be kept in mind, on the basis of which the validity of this entire schedule was upheld, 10th schedule was upheld. Kindly come to 235. The purpose of referring to the said article is to highlight the nature of participation of the speaker.
Yes.
I'm sorry, my lord, if I'm missing something.
No, yes.
The purpose of referring to the said article is to highlight the nature of participation of the speaker when the question of his removal arises. It is clearly different under the Constitution. He is entitled to take part in the proceedings and speak. Therefore, he is in a position to contest. Appreciating the scheme of the Constitution and especially keeping in view the language employed in the first provision, Article 179C, it is quite clear that it is the constitutional design that the Speaker should not do any act in furtherance of his interest till the resolution is moved. Then 237. The aforesaid reasoning eloquently speaks of the power, position, and the status of the office of the Speaker enjoys under the Constitution. It also states about the scope of the fiction. The court has constricted the power of judicial review and it has restricted it to the state, carving out certain extreme exceptions. It is because the Speaker, while exercising the authority, jurisdiction, exercise the power of constitutional adjudication, the concept of constitutional adjudication as constitutional value in a parliamentary democracy and constitutional value sustain the democracy in a sovereign republic. The Speaker is expected to maintain propriety as an adjudicator. The Speaker, when functions as a tribunal, has the jurisdiction, authority to pass adverse orders. It is therefore required that his conduct should not only be impartial, but such impartiality should be perceptible. It should be beyond any reproach. It must reflect the trust reposed in him under the Constitution. Therefore, the power which flows from the introduction of 10th schedule by constitutional amendment is required to be harmoniously construed with Article 179C. Both the provisions of the Constitution are meant to subserve the purpose of sustenance of democracy, which is a basic feature of the Constitution. Manurula were speaking about democracy as opined that democracy in India is a product of rule of law and it is not only a political philosophy but also an embodiment of constitutional philosophy. Thus, regard being had to the language employed in Article 179C of the Constitution and the role ascribed to the Speaker under the 10th schedule, it is necessary that Speaker as a tribunal has to have complete detachment and perceivable impartiality. When there is an expression of intention to move the resolution to remove him, it is requisite that he should stand the test and then proceed. That is the intendment of Article 179C, and the said interpretation serves the litmus test of sustained democracy founded on rule of law, and the founding fathers had so intended, and the constitutional value, trust, and morality unequivocally to suggest. It would be an anathema to the concept of constitutional adjudication if the Speaker is allowed to initiate proceedings under the 10th schedule to the Constitution after intention to remove him from office is moved. The 14 days period being mandatory, the words all the then members gain more significance. The Constitution has confidence in the Speaker. I would like to call it repose of constitutional confidence. Simultaneously, the command is to have the confidence of the majority of the actual or real figure. This understanding is gatherable from the express provisions of the Constitution, and it clearly brings in harmony between constitutional confidence or trust and the constitutional control. Be it stated, the position has to remain the same even after introduction of 10 schedule to sustain the robust vitality of our growing constitution, and it embraces the seminal spirit of rule of law that control all the powers, even the prerogative powers. So, my lord, therefore, this is how, my lord, the court brings in a balancing between these two, my lord, apparently areas which may be in conflict with each other, but your lordships, my lord, brought an interpretation to ensure that it is a smooth functioning. Now, my lord, this is founded on the principle of elimination of conflict of interest. And, my lord, that conflict of interest, when it is required to be demonstrated in a process of constitutional adjudication, your lordships laid down the duration of rule against participation of the speaker from the date of issuance of that intention of notice of moving the resolution and its completion when the resolution is moved, and, my lord, whether it is sustained or it is not sustained. So that's the first respectful submission, my lord. Does not require any fresh look, because these reasoning is very, very sound, my lord, and is based on the principles which have stood the test of time. Now, my lord, if your lordship may then come to kindly move a little ahead on the next part of my note, my lord. My lord, Rana was pressed time and again with utmost respect to the other side. Please see Rana. Rana is a judgment which clearly reveals and clears the way for entertaining a disqualification directly by the courts. My lord, Rana is a case, my lord, and I will only make one line submission here, which has also been made earlier. The original disqualification petition is considered by the speaker. It is then met a fate of its non-sustainability by the High Court. The matter when came to your lordship, no, your lordship then said, now there is no need to remand and we will rule on it. To rely on this judgment to say no, it gives a permissibility to the other side to raise a submission that the speaker's jurisdiction should now get vested with the courts, and courts should come under an obligation to consider such a petition at the threshold. My lord, is not permissible. It, my lord, it would not deserve any approval by your lordships. My lord, page 13. There cannot be and should not be any deemed, my lord, disqualification. My lord, civil consequences, compliance with principles of natural justice, prejudice caused on the removal of an elected member of the House. My lord, it would be, with utmost respect to my friends on the other side, would be preposterous to even suggest that when a particular action can have such consequences that you remove an elected member, inflict an election again on the same constituency. Can there be that there is no notice and hearing? Because, my lord, to say that there is a deemed disqualification is making a submission of complete elimination of any process to be followed before giving that, my lord, position. No process to be followed. If a gentleman, according to that test, commits an act, he must go home straight away, whether elected by a constituency of, say, 20 lakhs people. My lord, MP constituency now between 16 to 20 lakhs. So the expression of their will toward the democracy must suffer a deemed removal, a negation totally, or totally unknown to any civilized society norms. Forget the constitutional scheme. The suggestion itself, mother, with utmost respect, is preposterous. Should not deserve, my lord, even to be entertained as an argument. And, my lord, only thing which I want to rely additionally, a judgment of 3 judges, my lord, of your lordships, which I have cited, my lord, at page 13, para 7, where, my lord, leading evidence in a 2-1A petition Your Lordships have remanded it back that full opportunity, including leading of evidence, would flow from 21A. Malad, this is 2022 to SCC 759. A short judgment, Malad. I'll leave the copy with your
Manipur judgment.
I'm sorry.
Manipur judgment.
Yes, my lord. Now, my lord, after that, I want to read 122 in this background, my lord. We start from page 14, 122 of Kyoto. My lord, intra-party dissent was one of the argument to, my lord, to establish unconstitutionality and invalidity of the 10th schedule. That the one of the rights of elected candidates is to speak against their own party if need be. That itself is a part of democracy. That how much I can speak on various large public interest issues within my party or outside against my party. Can this be curtailed totally in the name of party discipline and embarrassment to the party? Can it be curtailed totally? Should it be eliminated? Your Lordships upheld the validity and kindly make a note of para 44 of Kyoto, 17, 44, 121, 122 and 123. Let me repeat, my lord, 17, 44, 121, 122 and 123. Now, my lord, your lordship may also make a respectful, kindly consider a respectful submission. If your lordship may kindly see clause 2 of the 10th schedule, which is reproduced at page 14. My lord, the grey area now only remains is 21A. 21B, your lordships have decided in Kyoto 122, and I'm going to read it, my lord. My lord, your lordships have dealt with this matter even in the 239 AA first round of the Constitution bench. Any and every direction. What is the meaning of any in such constitutional provisions? Kyoto, my lord, is relied upon in the 239 AA by your lordships. In paragraph, it says, any can't mean every. Number 21B uses the word any direction. Kindly have a look at 21B. If he votes or abstains from voting in such house, contrary to, please mark the next word, any direction. So the argument raised was, wherever any is, it would include every. Any has no other meaning but to be every. So this was pressed into service that the language is so clear, how can this be curtailed? Now, my lord, if your lordship now kindly see page 15 where para 13 of Kyoto is reproduced, Kyoto dealing with 21A says, literally meaning 21A means when you leave a party. When you leave a party, that is 13. 17, my lord, your lordships record the contention on intra-party dissent to remain a very, very important right of every elected member. Kindly now come to my lord 121 at page 17. 121. 44, my lord, your lordship may make a note. I am not reading it. I'll just bother your lordship from 121 and 122. Your lordship may also add 123 there, but I want to read these two. We may now notice one other contention as to the construction of the expression, any direction occurring in para 21B. It is argued that if the expression really attracts within its sweep every direction or whip of any kind whatsoever, it might be unduly restrictive of the freedom of speech and the right of dissent, and that therefore should be given a meaning limited to the objects and purposes of the 10th schedule. So, state question, my lord, and your lordships utilizes the, my lord, interpretation by limiting that power. Kindly see 122. While construing para 21B, it cannot be ignored that under the constitution, members of the parliament as well as the state legislators enjoy freedom of speech in the house through this freedom is subject, though this freedom is subject to the provisions of the constitution and the rules and standing orders regulating the procedure of the house Article 1051, 194(1), the disqualification imposed by 21B must be so construed as not to unduly impinge on the said freedom of speech of a member. This would be possible if para 21B is confined in its scope by keeping in view the object underlying the amendments contained in 10th schedule, namely to curb the evil or mischief of political defections motivated by the lure of office or other similar consideration. The said object would be achieved if the disqualification incurred on the ground of voting or of abstaining from voting by a member is confined to cases where a change of government is likely to be brought about or is prevented, as the case may be, as a result of such voting or abstinence, or when such voting or abstinence is on a matter which was a major policy and program on which the political party to which the member belongs went to the polls. What was your manifesto? How did you go to the poll? What presentation you made? For this purpose, the direction given by the political party to a member belonging to it, the violation of which may entail disqualification under para 21B would have to be limited to a vote. Now, kindly see, my lord, would have to be limited to. Please mark this word one here, my lord, because these are only two situations. One, first, a vote on motion of confidence. That is number one. So it is limited to only two situations. One, when there is a vote of confidence in the house, and where the word starts, my lord, or it is two. Or two, no confidence in the government, or where the motion under consideration, I'm sorry, my lord, the second or, the two is where the motion under consideration relates to a matter which was an integral policy and program of the political party on the basis of which it approached the electorate. The voting or abstinence from voting by a member against the direction by the political party on such a motion would amount to disapproval of the program on the basis of which he went before the electorate and got himself elected, and such voting or abstinence would amount to a breach of trust reposed in him by the electorate. Kindly see, there is a coalition. They left the coalition, they got the votes on coalition, and the argument is made against us. The vote is by the coalition. You are responsible for that vote which is given in your favor on that presentation. Therefore, my lord, dissent against the leader. So therefore, my lord, my respectful submission is this, that 122 restricts it to only two kinds of whips or direction which fall within the purview of 21B. There is no other whip or direction which your lordships have now permitted to be falling within the purview of 21B. I go a step further, my lord. If, my lord, there is a vote in the house, two situations can be there. There can be a whip, or it is absence of any whip. Can it be said, my lord, a whip to attend a particular meeting, not in the house, outside, nothing to do with the vote or a policy? Can it be put in 21A if it doesn't fall under 21B, because under 122 it doesn't fall under 21B? Any direction or a whip for any meeting outside, nothing to do with what? Or these two categories. It doesn't fall under 21B because precondition for 21B is a whip or a direction, which gets restricted only to two categories. Now, these two categories, when there is no whip, can it be brought by any speaker to say, I will put it under 21A now? Impermissible. It would be abuse of that process and usurpation of non-existent jurisdiction by the speaker. And they are raising it to a deem. There are two meetings of the party in the present case. Two meeting of the party, not for a house meeting for vote.
The merits of the matter, Mr. Maninder Singh.
I'm sorry, my lord.
These are on the merits of the matter.
I'm not on merits, my lord. I'm on the with utmost respect, my lord. I'm not going to the merits. I'm conscious.
This
With,
will only be in the context of merits only.
my lord, the
In the sense
judgment.
that, in the sense that Speaker could not have gone into this issue.
I'm on the other, I'm deeply obliged, my lord. Your lordships are pointing out to me. I'm conscious. I'm only answering because one of the judgment which they have relied upon is that any direction which is not complied with, therefore we are saying it is a per se automatic disqualification.
You are answering that per se point that even we should not decide in this manner.
I'm only, my lord, I'm respectfully only saying that judgment, my lord, I showed to your lordship that judgment also doesn't say so, because in your lordship may straight away come to at this point, my lord, kindly come to page 29 of this note. I'll come back a little later, my lord. Kindly come straight away to 29. I'll finish in, my lord, next 5-7 minutes. Kindly see page 29. My lord, repeatedly, my lord, an argument is made that for not attending the meetings and defying the direction on that account is per se disqualification. And kindly see at page 29, Srimant Balasaheb Patil's case, my lord, which is pressed into service again and again. Only 3 points on that, my lord. They had resigned from the party, those 17 MLA, number one. Number two, they failed to attend two meetings which were not 2-1B meeting. And three, failed to attend the trust vote, violating the whip leading to falling of the government. Not the other meeting. So your lordship said, in the light of these facts, we declare that this is the consequence. What I am highlighting and, my lord, pressing in service before your lordship kind consideration, define the whip for attending the trust vote in the house. That, my lord, this judgment doesn't have any applicability in our case. And, my lord, similarly, if you kindly see page 28, all the three cases, my lord, which have been relied upon, there is something more than not coming to the meeting. Kindly see, my lord, Ravi Nayak, the two members of one political party, MGP, supporting the chief minister of the other party. Then secondly, Maninder Singh, he was elected on the Congress ticket and then as MLC and then goes as an independent, leaving that party. Similarly, Mullah Rana, they say 13 candidates say, no, bring the Samajwadi party into power. And, my lord, followed by the Sriman Balasaheb, there is a defiance of not attending the meeting in the house when the vote is to take place and the government falls. And last, my lord, my last submission is, kindly, my lord, come back to the judgment, my lord, of Yadurappa. My lord, at page 22, my lord, of this.
Opportunity to Mr. Mehta today.
I'm finishing, my lord.
No, we just.
My lord, I am counting, my lord. I have only taken approximately 20 minutes.
Give some opportunity today to him or tomorrow. That is
Today, my lord, today. It's right.
today.
It is on its way, my lord, today.
Right time to begin, Malak, for me.
Last word also.
Very dangerous. Very dangerous. Begin, Malak.
True.
My lord, I knew at serial number 4 I will have this, my lord. Your lord,
Fix with the fading light.
your lordship
No, you can.
enormous patience, my lord. I will not test it, my
No,
lord. I can't afford to do that. Only last submission, my lord, last.
No, you continue.
No,
My lord,
Ravinder, come this far, go ahead.
Inter-party dissent, my lord, which became the subject matter of judgment in Yadurappa's case, my lord. It came from High Court, my lord. There was a dissent between two honorable judges, Honorable the Chief Justice and Justice Kumar. And then, my lord, Justice Kumar didn't agree with the Honorable the Chief Justice, Justice Kehar there, my lord, and the matter was referred to third judge. And your lordships, my lord, the Honorable the Chief Justice Kehar had held that they are stood disqualified. The third judge agreed with the Honorable the Chief Justice. Justice Kumar's view was no, they have not been disqualified because they were opposing the leadership of Yadurappa. Your lordships accepted that judgment of Justice Kumar, and my lord held that it was not a disqualification. I've only, my lord, taken the liberty to reproduce 2-3 paragraphs from Justice Kumar's view, which is para 45 and 62 at page 22 and 23, which I am not reading. I want to read few portions of 3-4 paragraphs of your lordship judgment in Supreme Court in Yadurappa, and thereafter sit down immediately. Page 22 and 23 of that note. 45 and 62 I'm not reading. Your lordship may just mark it. I only want to read 2-3 paragraphs in here. My lord, I will do it without even your lordship.
All right. Page 22 and
Yes, my
23.
lord. Kindly come to my lord. Para 122 again. They are not leaving us for para 122 from Koito to Yadurappa.
Although Mr. Swaraj.
Yes, my lord. Although Mr. Sarabji was at pains to point out the language used in the matter was similar to the language used in Article 356 of the Constitution, which according to him was an invitation to the governor to take action in accordance with the said article. The same is not as explicit as Mr. Sarabji would have us believe. The constitutional process as hinted at in the said letter did not necessarily mean the constitutional process of proclamation of president rule, but could also mean the process of removal of the chief minister through constitutional means. On account thereof, the Bharatiya Janata Party was not necessarily deprived of a further opportunity of formulate a government, forming a government after a change in the leadership of the legislature party. In fact, the same is evident from the reply given by the appellants on 9th. In reply to the show cause notice is issued to them, they re-emphasize their position that they are not only continued to be members of BJP, but would also support any government formed by BJP and by any other leader other than Shri so-and-so of the state. The conclusion arrived at by the speaker does not find support from the contents of that letter. It so as to empower the speaker to take such drastic step as to remove the appellant from the membership of the House. 128. In arriving at such conclusion that by such short notice, no prejudice has been caused to the appellant since they had filed their detailed reply to the show cause notice, the speaker had relied on two decisions of this court in Mahechandra Prasad Singh and Ravi Nayak, wherein it had held that 1986 rules were directly and not mandatory in nature, and as a result, the order dated 10-10-10 could not be set aside only on the ground of departure therefrom. Even if less than 7 days time is given to reply to the show cause notice, the legislator must not be prejudiced or precluded from giving an effective reply to such notice. The procedure adopted by the speaker, para 147, seems to indicate that he was trying to meet the time schedule set by the governor for the trial of strength in the assembly and to ensure that the appellants and the other independent MLAs to disqualified prior to the date on which the floor test was to be held. Having concluded the hearing on 10-10-10 by 5 p.m., the speaker passed a detailed order in which various judgments both of Indian court, foreign court and principles of law from various authorities were referred to on the same day, holding that appellants had voluntarily given up their membership of BJP by their acts and conduct, which attracted the provision of 21A of 10 schedule to the Constitution, whereunder they stood disqualified. The vote of confidence took place on 11-10-10, in which the disqualified members could not participate, and in their absence, Shri so-and-so was able to prove his majority. Unless it was to ensure that the trust vote did not go against the Chief Minister, there was no conceivable reason for the Speaker to have taken up the disqualification application in such a great hurry. Although in Dr. Maheshchandra Prasad case and in Ravi Naik's case, this court had held that the disqualification rules were only directory and non-mandatory, and that violation thereof amounted to only procedural irregularities and not violation of a constitutional mandate. It was also observed that Ravi Naik case that such an irregularity should not be such so as to prejudice any authority who is affected adversely by such breach. In the instant case, it was a matter of survival as far as the appellants were concerned, In such circumstances, they deserved a better opportunity of meeting the allegation made against them, particularly when, except for the newspaper cutting said to have been filed by Shri so-and-so along with the disqualification application, there was no other evidence at all available against the appellant. Having considered all the different aspects of the matter and having examined the various questions which have been raised, we are constrained to hold that the proceeding conducted by the speaker on the disqualification application do not meet the twin test of natural justice and fair play. The speaker, in our view, proceeded in the matter as if he was required to meet the deadline set by the governor, irrespective whether in the process he was ignoring the constitutional norm set out in the 10th schedule to the constitution and the disqualification rule, and in contravention of the basic principle, and go hand in hand. The appeals are allowed. Order of the speaker was set aside. So, my lord, this is the test which your lordships have laid down, and my lord, therefore, I appeal to your lordships, my lord, that this case, my lord, with your lordships now deciding on that day of deference of, my lord, consideration to refer the Nabam's decision to larger bench. Insofar as the other points are concerned, nothing would survive, my lord. That's our respectful submission. It is only academic, especially, my lord, when the gentleman concerned did not face the vote of confidence in the House. That's our respectful submission, my lord. Deeply obliged. So,
Thank you, Mr. Maninder Singh. Mr. Mehta, how long would you take?
But, 1 hour outer limit, maybe 5-10 minutes more.
Right. So by between 11 and 12, we'll give you an hour tomorrow. Mr. Sibyl, how long would you take after that? Between you and Dr. Singh.
I don't think so, Malas. I'll take the end of the day because 5 days have been taken this side, Malas. I might just respond.
But now I think we have to wrap
But
it up.
best bets is your lordships tell me which are the areas your lordships want clarification. I'll answer it. There's no issue. I have no
What
problem.
you can do is, Mr. Sibyl, you can start your rejoinder, and then if you feel that we can go to the next point, we'll tell you that.
There's no issue, Malas. I didn't trouble your lordships on the earlier occasion. I won't trouble you again, Malas. I'll just answer all the
But if
questions.
possible, it would be good if both you and Mr. Dr. Singhvi can.
That may not be possible, Malas. That may not be possible. That may not be possible. Your lordships have been so very
10
patient.
minutes of Mr. Kamath or 10 minutes of the clock?
Your lordships have been so very patient, Malas, with all
So
of us.
12 o'clock we'll start tomorrow.
Yeah, that's fine.
11 o'clock to 12 o'clock, Mr.
12 o'clock
Mehta,
is-
and 12 o'clock for your
I start,
rejoinder.
Malas. No issue.
12 o'clock will start.
Please. Okay.